Really appreciate her preparing those remarks. So I'm the faculty director of the ERA project at Columbia Law School. It's our third year, and we've just gotten so much accomplished in that short time under the leadership of Ting Cheng and our policy associate, Naomi Young. And what our job is, we see our job as kind of a think tank to take a deep dive into the remaining legal and policy questions that surround the ERA, and then how to get it to do some work in the world once it's finally ratified. So this panel of scholars is going to take up that responsibility and think hard with us about what those remaining speed bumps, if you will, are, and how we might resolve them. Who's responsible for resolving them? Is there a history of the same kinds of objections or concerns with other amendments to the Constitution? What's at stake? And where should we go from here in solving those problems? So let me hand things over to Josh Chaffetz, who's at the Agnes Williams Sesquicentennial Professor of Law and Politics here at Georgetown Law. Josh, thank you so much for chairing this panel and for these amazing panelists.
Thank you. Is this on? Thank you so much, Catherine and Vic, for putting this on and for inviting me to moderate this fantastic panel. I think what I'm going to do is start with just a few words myself about the procedural history of the ERA, and then introduce our panelists and ask each of them sort of a question to sort of lead off their contribution, and then open things up for discussion. I have just found out that this panel will be ending at 11:15 to make room for Representative Lee's address, so we're a little bit shorter of a panel than we had initially intended to be. Okay, so as you may already know, right, a proposed equal rights amendment was introduced in every Congress between 1923 and 1972. The version that was ultimately proposed by Congress to the states in 1972 had 3 sections, very short. Section 1, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Section 2, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. And Section 3, this amendment shall take effect 2 years after the date of ratification. The resolution proposing the amendment specified that ratification would have to come within 7 years from the date of its submission by Congress. On October 12th, 1971, it passed the House by a bipartisan vote of 354 to 24. That's about 94% of the House voting yay, well north of the 2/3 requirement. A few months later, on March 22nd, 1972, it passed the Senate by a vote of 84 to 8. So that's about a 91% yay vote in the Senate. And that, of course, began the 7-year ratification clock for ratification by at least 38 states. Hawaii, taking advantage of the 6-hour time difference from Washington, ratified on the same day that it was proposed by Congress. And by the end of that week, 6 more states had ratified. The 30th state, Washington, ratified exactly a year after the amendment was proposed by Congress. About a month and a half after Washington's ratification vote, the Supreme Court decided Frontiero versus Richardson, in which a plurality applied strict scrutiny to a sex-based classification, and indeed in which the plurality used the dependency of the ERA as a reason for applying heightened scrutiny to sex-based classifications. Over the next 4 years, 5 more states ratified for a total of 35 by mid-January 1977, and then the ratifications stopped. In 1978, Congress voted to extend the ratification deadline to June 30th, 1982, but to no avail. No more states ratified before that deadline either. And meanwhile, 5 states purported to rescind their ratifications between 1973 and 1979. Fast forward to the Trump administration, and for some reason, interest in the Equal Rights Amendment got renewed. In March 2017, almost exactly 40 years since the last state had ratified, Nevada passed a ratification resolution. In 2018, Illinois followed suit, and then Virginia in 2020. And then in 2021, North Dakota voted to rescind its ratification. So where we are today math-wise, I know most of you were told there would be no math in law school, but this is pretty simple arithmetic. So if you count all of the ratifications, including those that came after the initial deadlines had passed, and you conclude that the votes rescinding ratifications were inoperative, then 38 states have ratified the ERA, and it is, in fact, the 28th Amendment. And of course, there are good arguments that we will hear for all of those positions. During the Trump administration, the Department of Justice Office of Legal Counsel published an opinion arguing that the deadlines were binding and that the late ratifications didn't count. And it moreover argued that Congress could not revive the ERA once the ratification deadline had passed. If it wanted to bring the ERA back to life, OLC argued, it would have to propose it anew and begin the ratification process from scratch. A subsequent opinion from the Biden OLC backed away from the earlier opinion's claim that Congress could not revive the ERA without starting over. It moreover argued that, quote, whether the ERA is part of the Constitution will be resolved not by an OLC opinion, but by the courts and Congress. I wish they'd put those in the other order, but that's where OLC comes from. So that's where we are today. Okay, so let me introduce our panelists. I'll say just a word or two about each of them, and then I will sort of ask them each a question in turn and ask them to take about 5 to 10 minutes to sort of answer that question. So first of all, my colleague Michele Goodwin, who's joining us by Zoom, is the Linda D. and Timothy J. O'Neill Professor of Constitutional Law and Global Health Policy here at Georgetown, where she works on health law and reproductive justice issues. Julie Suk is a professor of law and the Honorable Deborah A. Batts Distinguished Research Scholar at Fordham Law School, where she researches matters of equality at the intersection of law, history, sociology, and politics, both in the United States and globally. David Posen is the Charles Keller Beekman Professor of Law at Columbia Law School, where he writes on constitutional law, information law, and nonprofit law, and has written on the history of the constitutional amendment process. And finally, last but not least, Linda Coberly is chair of the Appellate and Critical Motions practice at Winston and Strawn. She's argued nearly 70 appeals in federal and state appellate courts across the country, and she leads her firm's Women's Leadership Initiative and its pro bono efforts to fight for recognition of the ERA. Okay, so the first question is to Michele. And broadly, my question for you, Michele, is why does all this matter? Why do we still need the ERA today, in your view? And what difference would it make if we sort of woke up tomorrow and it were formally recognized as ratified as the 28th Amendment?
Well, thank you very much for the question, Josh, and congratulations to my colleague, Victoria Norris, and also to a colleague as well, Catherine Franke, for bringing about this very important convening. And I wish that I could be there with you all in person. So this question is, on one turn, a softball, and on the other hand, it's a question people really need to struggle with for being a softball question. We take for granted women's citizenship in the United States, and some are explicitly shut out or were let in only. This is something that is a struggle for people to comprehend when one takes a quick glance at C-suites. That is to say, seeing more women CEOs than ever before, more women who are executive directors of major organizations than ever before. If we peel those veneers and we see the fragility of what all of that represents, with women still comprising about 17% of those who make partner at law firms, a very thin representation of women in C-suites, a very thin representation, if we're talking about law, as women in general counsel's offices. And if we dig even deeper than that, we'll see that we are still on this very kind of fragile leaning that sets into motion in some ways by Sojourner Truth, so many decades and more than a century ago, where she asked the question fundamentally about citizenship, but is more for so many people about, am I not a woman? Not a woman. Is actually a twofold kind of question. Do I not deserve the status that white women enjoy? And it's also a question, is their status enough? These questions of citizenship that we have to remind ourselves frequently about. So much we've already heard about with regard to the arc of voting rights. And here I want to think about Fannie Lou Hamer, because it's the intersection of her life, both then in the civil rights era and also now, that really helps us to, I think, ground this question. For example, Fannie Lou Hamer hailed from state Mississippi. Mississippi is the state that brought us the challenge to Roe v. Wade and Planned Parenthood v. Casey, with its 15-week abortion ban that made no exceptions for rape or incest. The very telling order that kept that law from going into effect was written by Judge Carlton Reeves. And in so many ways, what he did was to resurrect a story about the need for an ERA. It's an intersectional need that grounds core ideas of citizenship and what it means across a plane of race, class, and sex in America.
Yeah. Michele, unfortunately, we're having technical difficulties. The Zoom keeps cutting in and out. Should we just move on and then maybe come back to Michele if we can get it finished? Okay. So sorry, I'm sorry, Michele. Yeah, we're gonna move on just because you're frozen on the screen here. So I'm gonna ask the next question to Julie. So what does the sort of path of the ERA thus far sort of teach us about the amendment process itself, and more broadly about our sort of constitutional structure, right? What sort of lessons can we take from this sort of long and winding road that the ERA has taken so far?
Great. Well, thank you so much to Victoria and Catherine and the ERA project in Georgetown for convening this. I've written a book looking at some of the questions called We the Women, the Unstoppable Mothers of the Equal Rights Amendment. So I'm going to just select very carefully from what's in there, but I'm looking at the entire history. And I think one thing we need to understand about the situation that we're in right now is that it's actually unprecedented. We've never before had a constitutional amendment that was adopted overwhelmingly, not just by 2/3, but overwhelmingly by both houses of Congress. And then with a 7-year deadline, we've never had to test the 7-year deadlines on previous amendments that use them. With the ERA, we have a very unique situation in the way that the deadline was formulated, specifically that the language used in the resolution said valid to all intents and purposes when ratified within 7 years in the preamble. And that's very different from the very clear-cut, absolutely enforceable expiration date deadlines that we've had on previous constitutional amendments, specifically beginning with Prohibition, the 18th Amendment, that said in the text of the amendment itself, invalid unless, inoperative unless ratified within 7 years. We've also had preamble language that said valid only if ratified. So when it's expressed when ratified, valid to all intents and purposes when ratified within 7 years, there's actually a very big question mark as to what the status of that amendment is when you get 3 states that are ratifying way after the deadline, when you also have some of these rescissions. And where we've gotten now, and in the book, I also tell this backstory, which I think is really important, that is often not recognized, which is that it was actually the ERA was passed by an overwhelming majority, over 90% in 1970 with no deadline. And it doesn't even come to a vote in the Senate because of obstructive tactics in the Senate, with which we're very familiar with now. And I think Josh's work has been great on this topic. But it's really in the 1970s that you see the death of so many constitutional amendments, including an effort to bring a national popular vote for the presidency. And it's because of obstructive techniques in the Senate. So we don't even get to vote in the Senate on an ERA without the 7-year deadline. And it's only because of these obstructive techniques, this kind of bullying in the Senate, that Martha Griffiths, the sponsor in the House, comes back in 1971, which is where Josh's story began. But the story is before 1971, we had no deadline and it could have passed. There was overwhelming support within the nation and even within the Senate for an ERA with no deadline. But it gets obstructed because of what we now call the filibuster and that obstructive technique. And I think that backstory is really important now for understanding what can and should happen. What can happen, and I think at this point, all 3 branches of government have recognized that what can happen is Congress can act. Congress can clarify any confusion as to the validity of those last 3 ratifications and the efforts to rescind by the 5 states and however many other states are talking about rescission now. So I think that we've had court decisions that have declined to declare the ERA ratified primarily on standing grounds, but have suggested in dicta that Congress is really has the power to act. We have Supreme Court jurisprudence suggesting that this question of timeliness is, particularly when there isn't a binding deadline put into the text of the amendment itself. We have longstanding Supreme Court precedent that suggests that it's a political question for Congress. And then certainly in Congress now, the efforts to pass these deadline removal or declaration of ERA ratified resolutions are a recognition of its own power to judge the timeliness of the amendment. And again, I think the main barrier has been that the filibuster in the Senate has meant that we have a majority of the Senate in favor. They voted cloture last April, showing that there was a majority in the Senate in favor of removing the ERA deadline, but it hasn't become law, or it's not valid because of the same obstructive techniques that have been a history of amendments in the direction of inclusion in our democracy.
Thank you so much, Julie. For Dave, I'm going to ask sort of the converse of the question that I asked Julie. So what light can the history of the constitutional amendment process, or thinking about other amendments, shed on the ERA?
Thanks so much, Josh, and to Victoria, Catherine, all the organizers for having me. I'm honored to be here at this inspiring event. I want to say at the outset, before taking up Josh's question, that I do not consider myself any kind of expert on the ERA specifically. My knowledge of the ERA pales in comparison to that of my co-panelists. I've been put on this panel instead because of some work I've done on the law and history of Article 5 amendments more generally. So that's where I'll engage. In response to Josh's question about what this history teaches us, let me start with the text of Article 5 and suggest that it is often described in the literature as an unusually clear and constraining provision of our Constitution. You need 2/3 of Congress plus 3/4 of the states. What could be more straightforward than that? Indeed, a unanimous Supreme Court wrote in a 1931 opinion, and I quote, that a mere reading demonstrates that Article 5 is clear in statement and in meaning, contains no ambiguity, and calls for no resort to rules of construction, end quote. Yet, while the language of Article 5 may seem straightforward, in reality, it leaves open a long list of fundamental questions, from whether and how any temporal or substantive limits may be placed on an amendment, to the role of presidents and governors, among others, to perhaps most fundamentally and pertinent for today, who gets to decide whether an amendment has satisfied the rules of Article 5 and become part of the Constitution. Nor did the framers of the Constitution back in the 1780s give us much guidance here. As one scholar observed in a major study of the Philadelphia Convention at which Article 5 was drafted, and I quote, "The consideration of amending procedures was one of the least adequate of convention debates." And the same was true of the state ratification debates that followed. Very little was said or clarified about how Article 5 would work. So you may be thinking at this point, well, okay, even if the text and original meaning of Article 5 don't yield much guidance, surely the law of Article 5 is much clearer at this point. Surely over 2 centuries of lived experience with this amendment process has yielded a long list of judicial decisions and congressional executive settlements that have filled in those ambiguities and gaps. It turns out, however, that this is just not the case, or at least much less than you might expect. It turns out that the overwhelming majority of the 27 amendments we now recognize as part of the Constitution faced credible legal challenges at the time to their compliance with Article 5. Challenges that were beaten back by proponents at the time, but have never been definitively dispelled or resolved. The first 11 amendments that gave us the Bill of Rights were not, for example, presented to the president, even though another part of the Constitution, Article 1, Section 7, Clause 3, states that, and I quote, "Every order, resolution, or vote of Congress, plausibly including proposed amendments, shall be presented to the president and must be approved by the president before they take effect." Some distinguished scholars have therefore claimed that the first 11 amendments, among others, are invalid as a result of not being presented to the president. The 12th Amendment, the next one we got, which sets the rules for electing the president, was passed by less than 2/3 of the full Senate. It was passed by only 2/3 exactly of a quorum of the Senate, not 2/3 of the full body, even though this arguably conflicts with the supermajoritarian letter and spirit of Article 5. More famously, the framers of the 13th, 14th, and 15th Amendments that came next, the Reconstruction Amendments that gave us our nation's second founding, took a number of highly unusual and aggressive maneuvers to prevent obstruction by the former Confederate states. Maneuvers that everyone understood at the time were legally doubtful, though practically necessary in the wake of the Civil War. Next time around, with the 16th Amendment, authorizing a federal income tax, the states ratified inconsistent versions of the text of that amendment, even though there are plausible arguments that states have to ratify an identical text for that text to become part of the Constitution. The 17th Amendment, providing for a direct election of senators, was passed by the U.S. House and Senate during different Congresses, different legislative sessions. So was the 13th Amendment, for that matter, even though some scholars, including Sai Prakash in a recent Harvard Law Review article, contend that amendments, like ordinary bills, must be passed in the same legislative session in both houses to be valid. The 18th Amendment, giving us prohibition, was initially invalidated by a district court on the ground that it was supposed to be taken up by state conventions rather than state legislatures. That amendment was in turn repealed by the 21st Amendment, which sparked yet another round of fierce legal debates about how state ratifying conventions would operate. The catalog of, I won't go on too much further here, but you get the idea. The catalog of legal controversies just is endless when we look at the amendments that we now treat as clearly part of the Constitution. One more example in our own time is the most recently recognized amendment, the 27th, which prevents Congress from giving itself a pay raise before an intervening election, that was ostensibly ratified in 1992, over 200 years after it had been proposed by the initial Congress that also proposed alongside the Bill of Rights. I say it was ostensibly ratified in 1992 because as far back as 1921, a unanimous Supreme Court, including justices like Brandeis and Holmes, indicated in dicta that they saw that amendment as clearly dead and unrevivable. And numerous prominent constitutional scholars have argued that in light of this extraordinary delay between the proposal of the 27th Amendment and its ratification, the so-called 27th Amendment, and here I quote Bruce Ackerman, should be treated as a bad joke, end quote. And yet Congress has recognized the 27th Amendment, and it's in all the constitutions that we have in our case books and everywhere else. So what does all this teach us to come to the point about the ERA and where we are today? I see two main lessons, and I'll suggest here. Beyond the specific legal questions that the ERA poses, which are distinctive to it, and Julie and Josh began to summarize, I think the history affords two broader takeaways that might bear on the niceties. The first is that for all that's distinctive about the ERA and the questions of the expired deadlines and the rescissions, there is nothing distinctive or unusual about all the legal uncertainty that surrounds an attempted amendment, such as the ERA. On the contrary, as I've tried to convey, attempts to amend the Constitution have always generated difficult legal puzzles and debates. Critics of the ERA say it hasn't clearly satisfied all the requirements of Article 5 and therefore is suspect. The same could be said of every amendment that we recognize as part of our Constitution. To put that point a little more abstractly or provocatively, perhaps, we might say that what we call the Constitution isn't so much a collection of texts that have passed through a specific legitimating process as it is a collection of texts that Americans agree to act as if they have satisfied that process, even though serious questions arose for each of them as to their compliance. Okay, not getting spooked by the fact that the ERA raises these tough legal questions is my first suggestion. Second and last one is that perhaps a little less obvious and more debatable is I think the history also suggests that the fate of Congress, fate of the ERA should rest primarily in the hands of Congress now. Because the law of Article 5 is so unsettled, controversies are going to keep arising as to whether a proposed amendment has satisfied Article 5. And it's going to be important to have some means of resolving those controversies authoritatively and peacefully. The president could weigh in more or less helpful ways, but presidents have not played any decisive role in the past in this domain, nor is there anything in the text of Article 5 that would suggest they should. The judiciary is the more obvious place to look, but the Supreme Court has only squarely addressed the meaning of Article 5 a handful of times, the last time over 90 years ago, and many of the court's statements in Article 5 are just dicta, unreasoned assertions, or both. Not only that, several of the statements that the court has made about Article 5 have been blatantly contradicted by subsequent practice. Just to give one example, the court said in the national prohibition cases in 1920 that amendments need a vote of 2/3 of the members present in each chamber of Congress to get out to the states. And yet the 22nd Amendment was approved by the House in 1947 without clearing that threshold that the court said was necessary. When you try to change something as foundational as the text of the Constitution itself, it turns out the court is not well equipped to resolve a lot of the disputes that come up. As 7 justices wrote in the 1939 case Coleman versus Miller, disputes over Article 5 are often going to involve so-called political questions that aren't well suited to judicial review. Many Article 5 controversies don't give rise to justiciable controversies in a timely fashion. The court's precedents are thin and not well ordered in this area, and debates over Article 5 are going to involve highly charged, legally underdetermined judgment calls that tax the court's competence in its own legitimacy. So it seems to me then that we shouldn't expect anything good from the courts when it comes to the ERA, and shouldn't rivet attention either on executive branch actors like the archivist. To my mind, Congress is left as the least bad option here. Consistent with the text and history of Article 5, I think that Congress should understand itself to have the power to change the deadline that it originally sought to impose on the ERA. I likewise think that Congress should understand itself to have the power to decide how to treat the most recent state rescissions. And more generally, I think that Congress and not the courts should be seen as a primary arbiter of an amendment's validity when questions about Article 5 arise. None of this resolves exactly how Congress should proceed now with the ERA. I'm sure we'll be talking about that throughout the day. But the suggestion I'll close with is that, which I think is consistent with Julie's remarks, is that members of Congress should defend with vigor their institutional prerogative to be the arbiter of Article 5 compliance. And they should remember that navigating Article 5 has always required a great deal of not only political will, but also constitutional creativity. Thank you.
Thank you very much. And that, I think, is a great segue into my question for Linda, which is sort of where should proponents of the ERA go from here, right? Who should they be looking to? Do you agree that they should be looking to Congress? Should they be looking to the archivist? What should they be pressuring OLC to come out with a third opinion, right? What's the, what's next?
Well, I come to this from a slightly different perspective as an advocate, not a scholar, and it's actually an honor for me to be on this panel with scholars in the law school. And I do want to thank Vic and Catherine for inviting me and for hosting this event. One of the things I think is so important about this event is that it does bring together scholars and activists. And that is really critically important. My work on the ERA causes me to be in contact with activists very frequently. Many of my friends in the activist community are here in the room. I often say to the activists, remember that what we are doing here is a law thing. We are recognizing a real problem in our world, a real threat to equality, a real need for the recognition of equality. And we are choosing in part to solve that problem by changing the Constitution, which is a law thing. And as a result, we need to hear from scholars about the best way to do that, the best strategies, et cetera. Now, the other thing I can say as an advocate is that I also can recognize the practicality of wanting to win, because that's what I do all day, is I try to win, right? So I can recognize the merit in the legal arguments that were made, for example, in the litigation, where, and I will commend to you, there were a lot of wonderful briefs filed in the litigation, including in the DC Circuit. This was a litigation that was brought by the attorneys general of the last 3 ratifying states. And that litigation was unsuccessful, as Julie mentioned, largely on standing grounds. But the briefs in that case really demonstrated the legal argument for why the ERA is valid as the 28th Amendment today. And that's because Article 5 offers no role for deadlines. The text of the amendment itself does not contain the deadline, and it is that text that went through the ratification process. So to the extent that you see, for example, in the Prohibition Amendment, a deadline that was in the text of the amendment as being part of what was ratified, that's not true of the ERA. So I think there is a very good plain language argument for why the ERA is valid today as the 28th Amendment. And one thing you may read for that argument is a really excellent brief that was filed by Kathleen Sullivan on the part of a number of prominent constitutional scholars making that argument. But I also want to win. And I think the way we win is by pressing Congress. And that's because of a case that Professor Posen mentioned, Coleman v. Miller, which is one of, again, few cases on Article 5, but it has good language suggesting that Congress has the power to resolve things that are ultimately political questions in connection with the ratification process. And that's why I think the activities in Congress are so important. If we can get a vote in Congress to remove the time limit, then we stand the best possible chance of defending the ERA as enforceable in the courts, because we ultimately need to do both. We need to move around and act as if the Constitution has been amended, which I believe it has, but we also want to win, so we also need Congress to act because that gives us the best possible argument. So what's the status of that? Well, HJ Res 25 is a resolution that was sponsored by Representative Ayanna Pressley. It has 212 co-sponsors along with Representative Pressley, and it is currently stuck in the House Judiciary Committee. As you heard Representative McClellan explain a moment ago, there is a discharge petition. And I will say I am a commercial litigator, and so I'm learning some things about constitutional and congressional practice. But a discharge petition is a petition, if it gets enough votes, that would take the measure out of committee and send it directly to the floor. If the measure got to the floor, we believe it would pass. And one of the reasons we believe it would pass is that a similar resolution passed in the last Congress, including with 4 Republicans voting in support. At the same time, and I should say currently that discharge petition has 211 signatures and it needs 218. So if you're looking for something to do, there are people to call, and there are people in this room who can help connect you with the people to call. SJ Res 4 is a Senate resolution that was sponsored by Senator Ben Cardin, who's going to be with us later today, and Senator Lisa Murkowski. It came up in the Senate last April for a procedural vote, cloture to proceed, and a majority supported it, but not enough to overcome the filibuster. But the majority leader, Senator Schumer, he filed a motion to reconsider at the time, so it would still procedurally be possible to have another vote this Congress. So can we overcome the filibuster? I don't know. I think that's going to be really difficult in this environment. And one of the things I think that you've heard from my colleagues here on the panel is that amending the Constitution is difficult and messy. I think that fact demonstrates the difficulty with a truly originalist and plain language reading of the Constitution, because you would think if you were going to rest on the plain language of the Constitution would be a little bit easier to change. It's obviously quite difficult to change. But even if we were to get a vote of a majority in both houses and not a filibuster-proof majority, that would go some part of the way to give us better arguments when the ERA is inevitably embroiled in another litigation. So I think Congress is the best next step. Now, let me talk about the archivist for just a second. There's been a lot of focus on the archivist. As you may know, the archivist is the member of the government who is tasked with the responsibility of counting up the resolutions and the ratifications, saying when she has enough, and then publishing the amendment as part of the Constitution. This is a ministerial role. It's not a legal role. And so one thing I think we all need to recognize is the archivist publishing the amendment would not solve the questions. It would simply be part of the process. Now, I personally think as an advocate that would be helpful. It would be helpful if the archivist published the amendment because of politics and momentum, and we might actually be able to walk around with pocket constitutions that said the ERA is the 28th Amendment, and that would be really great for lots and lots of reasons, including expressive ones that are really important. But it wouldn't solve the problem. And that's why I think so much attention needs to be paid to Congress. Currently, the administration, in the second OLC opinion, the Department of Justice in its brief, statements by the president, they have all underscored the power of Congress to act. And I think we need to have our focus there to make sure Congress does act, because that will put us in the best possible position to defend this very important amendment in the inevitable legal battles.
Thank you very much. And I want to see if we can come back to Michele. Hopefully we have a better connection this time. Michele, I think when we lost you, you were talking about Sojourner Truth.
That's right. So let me say this, that at the time in which Sojourner Truth presents to the United States, people in the United States who are assembled to think about women in society, she's making a call that is quite relevant today. And that is a call about the status of women vis-a-vis their bodies in the state, the status of women vis-a-vis their ability to be able to engage in suffrage. These are some of the same questions that we see in the United States right in these times. Just this week, with the Arizona Supreme Court upholding a law from 1864, which banned abortion before Arizona was even a state itself, says so much about the urgency of rethinking what equality means in the United States and how important that is to our country moving forward. Let's remember that though we are a very young country relative to so many of our peers, we have a rather old Constitution itself. We have a Constitution that does not reflect many modern constitutions across the world where equality, sex equality, has been embedded in those constitutions. It's not something that we've done. And if one were to take a look at how urgent this is in terms of the lives of women, and I flagged Fannie Lou Hamer and the Dobbs decision, then there's much that one can see. Very recently in the state of Mississippi, while women stayed in line, and men too, for hours and hours, they were disenfranchised from the ability to be able to vote because ballots had run out in the very limited places where they could actually vote in these times, and such that their votes weren't able to be meaningfully counted or how they would have wanted to be able to vote. And I want to close on this so that we can spend the remainder of the time with the other questions that you have, which is that this important piece of our democracy flashpoints right with an intersection of reproductive health. And this is where I think back about Fannie Lou Hamer. Famously, the Mississippi appendectomy, not an appendectomy at all, but coercive sterilization in that state, something that she experienced firsthand and something that she told the United States about at the Democratic National Convention. And it was a very telling exposition that I think has relevance for us today in these times, as she connected what her life was in Mississippi, what Black people were brought through in that state, coercive sterilizations, suppression with regard to their vote, a lack of power in so many ways. She concluded her remarks with saying all of this because they wanted to be citizens. And what she was talking about, all of this, was that on the very day in which she and a group of Black women had attempted to vote in Mississippi, a place that was notorious for making Black people guess how many bubbles on a bar of soap, how many jelly beans in a jar, reciting the state's constitution, one can say that the methods have changed, but voter suppression is still alive in Mississippi. And she spoke about something else, which I'll end on this, and that is the threat of violence for being able to exercise what was instantiated as a right, being taken to jail and then being harmed by both law enforcement and also by men in the jail who were forced to beat her and these other Black women. And it's on that note that she concluded with the question for all of America to hear, And that was all of this just because women like her wanted to be equal and wanted to be treated as full citizens. I would argue that really what we have here is not only an arc towards the ERA, but fundamentally it is tied to questions about women's full citizenship in this country. And we could talk about what it means in terms of parity in Congress, what it means in terms of parity on our courts, what it means in terms of economic power. All right, I'll end there. Thanks very much.
Thank you so much. So I think because we need to end this panel early for Representative Lee, we have just a few minutes left. So I actually just wanted to ask sort of one more question and sort of maybe throw it out to all of our panelists, if any of you feel like responding, which is, Linda, you used the phrase that this is a law thing. And I want to pose the other sort of half of that, which is that this is a culture thing, right? So I noticed, for example, that almost all of the discussions so far have used have referred to this text as the ERA, not the 28th Amendment, right? We have all of these questions from Dave about sort of, well, everything, all of these different amendments were, had all these procedural problems at the time, any one of which presumably could have sunk any one of those amendments. And yet culturally, we have come to consensus that these things are amendments and therefore we treat them as amendments. What is the non-law role here, right? What is the role of constitutional culture? I was thinking even down to the sort of procedural details, right? So the claim that Congress is the right body for this, the question of how does Congress resolve this and how would we accept that, right? So my understanding is that the 1978 extension of the time for the ERA came in the form of a joint resolution that was signed by President Carter. Do we need to go through the presidency to extend the time, even if we don't need to go through the presidency for the, and who would make that decision, right? So I guess the question is, what does it take for us as a political community to accept a constitutional amendment, and what are the sort of roles that are not sort of made strictly in terms of legal argumentation that would point the way towards that? Question.
Well, one thing I'll say as an advocate is if any of these things happen, it makes the argument better, right? So getting a majority vote in both houses of Congress, which we actually already have, right? We have a majority vote in the Senate, and we had a majority vote in the last Congress in the House. So that already is an argument, right? Would it be a better argument if there was a filibuster-proof majority in the Senate? Yes. Would it be a better argument if we could get a vote by both houses in the same congressional session? Yes. Any one of these things helps to improve the argument, and it may be that the argument is all we have for a period of time, especially given, I think, David's excellent research that shows that all the amendments are subject to arguments and questions.
Julie, did you want to come in on that?
Sure. Well, I think it's a real puzzle because at around the time that Nevada, Illinois, and Virginia were ratifying, one important point was that a very large majority of Americans actually believe the ERA is already part of the Constitution. And so you might say culturally, isn't that sufficient to make the ERA part of the Constitution? And I think there's another piece of it which is really important, which is that we're a law venerating society, so that even the mere belief is not sufficient. I think that many Americans will not actually accept the legitimacy of the ERA until probably all three branches of government express in some definitive way that it is. I don't think it has to be that way, but I think the conditions of sociological legitimacy depend a little bit on legal legitimacy, which is why everything that Linda has said, which is, well, you need all these different actors coming on board with it. You need it printed in the pocket constitutions, and not just printed in the pocket constitutions that the ERA project publishes, which are wonderful. And that's the one I carry around. I think there was a period like in the mid-19th century when the Titles of Nobility Amendment was printed. I saw one. It was really cute, one of these 19th century constitutions. And there was like a period of 20 years when it appeared in some editions. But I do think that unless and until there is a litigation, perhaps someone challenges a very restrictive abortion law, for example, using the Equal Rights Amendment, claiming it to be the 28th Amendment, and courts start recognizing the validity of its ratification. I I don't personally think that that should be what's required to legitimize an amendment, but I do believe that because of the extent to which Americans venerate the Constitution and law, and even the Supreme Court, I just don't think that we will reach full legitimacy until all of those things come into play.
Yeah, I see it the same way, I think, as Linda and Julie. My reading of the history is that the rule of recognition, if you will, for how we recognize what is a valid amendment or not, is really a matter of acceptance, whether government officials and ordinary people accept it as part of the Constitution. And what drives that is this messy, cultural question. But as Linda was saying, I think the more facts on the ground that are out there that suggest the ERA is the 28th Amendment, the better. So even though I don't see the archivist as the key actor, it could only help if the archivist were to publish the 28th Amendment, or President Biden were to weigh into that effect. In advance, but I think Julie's also getting at the fact that we have not only a law and constitution venerating culture, but a court fetishistic culture, more than I would like. But I do fear that if facts on the ground aren't laid down by Congress in particular, and to a secondary extent, the executive branch, on the ERA being the 28th Amendment in advance of courts taking it up, you're going to get very unfavorable rulings. And a lot of Americans in our court-centric culture will treat that as dispositive, though I don't think it should be. So that interplay among the branches is complex, but I think the political branches really are, Congress and executive ought to do something soon before we get unfavorable court rulings.
And let me just tie on at the end here, which is to say something that we've not talked about, our state ERAs. And so the function of doing that, which is expressive politically, is not just in Congress, and it's not limited to the president, but these have a role also in the states. We've seen that very recently in Pennsylvania and what that can do before a court. So, and one final thing I would say is that socializing this is also not just confined to the political space. It means actually thinking about how we are expressive in this domain outside of our legal settings, and what this means for people communicating, what this means for people in their lived lives on the ground. And I think that must be a feature of what is done. So thank you very much, Josh, for moderating, and it's just such a pleasure to be with my co-panelists.
Well, and with that, unfortunately, we're out of time for this panel. So please join me in thanking all of our panelists for wonderful presentations. Okay, so I guess we have about 15 minutes left. We're back. So I think at this point, it might be great to take some questions from the audience. Yeah.
Very quickly, I'm an international lawyer, this stuff. But in terms of socializing this idea, many Americans do not know that there isn't equal rights, certainly gender equality. This is an election, so shouldn't there be more discussion on the ground of nuts and bolts of what's going on? The second point is human rights, human rights are free. How does that play along with the discussion?
So I think one of the most significant arguments for sorry.
And Josh, would you mind repeating the questions, because I couldn't hear that? So unless we give a microphone to the audience members, if the questions could be repeated.
Sure. So there were sort of two parts to the question. Part one was about the sort of status of this being an election year, and the question of how the ERA should sort of play into our election-related discourse. And then the second part was about the sort of international law element of it and how it interacts with the UN Declaration of Human Rights, which contains a gender equity provision. So, yeah. Julie, does you want to try to?
Should I talk over the?
Yeah.
Can people still hear me? So I think one of the most important arguments for the Equal Rights Amendment has been just a modernization of our 18th century Constitution. Every Constitution written after the Universal Declaration of Human Rights copies the principle of equal rights between women and men into their Constitution. So we're a real outlier in the world. And I think we're an outlier also for having had very few or really no women at the founding as founding mothers in 1787. The Equal Rights Amendment is one of the few things that have been made with the participation of women in Congress and state legislatures. So it's a really important global principle that's missing from our Constitution largely by virtue of its age and resistance to formal amendment. So I think those things have been really important since the ERA was introduced in 1923, and certainly of greater importance since the 1940s and in the early 70s when Congress finally voted for it. As for your earlier question, maybe David and Linda might have observations. I absolutely think that because of the votes in Congress, the discharge petition this term, and actually the votes in the House in 2020 and 2021, which removed the deadline. This is an election year, so if there are enough votes in the House and the Senate to pass the resolution that lifts the deadline and recognizes the ERA as validly ratified, it should be for congressional seats and Senate seats. It should be a really important issue, not for the presidency as much, but I think for every congressional seat that is up, it should be an issue to know how each Congress person voted on these ERA removal resolutions. And I think that's really important as we get into November.
Yeah, on the election issue, it seems really clearer every day, unfortunately, that equality has to be a major election issue. And while the president doesn't have a very big role to play in the ERA ratification or in any ratification process, there are many, of course, other respects in which the presidency is really critically important, including with respect to mifepristone, for example, which, we just had a Supreme Court argument about mifepristone, but the whole policy could change in the administration on January 29th of next year. Absolutely, equality should be an election issue. It should be a federal one and a state one as well, because of the importance of state ERAs. And in this respect, I want to hold up an initiative by the ERA Coalition called Elect Equality, which you can Google, and which certifies candidates based on their positions on a variety of equality issues, including not only the ERA specifically, but LGBTQ plus rights, et cetera. And that's actually one other thing I did want to mention. Among the equality issues facing us today, one of the most important and critical is the assault on the rights of gender nonconforming people and LGBTQ plus people. And because of the Bostock decision of the Supreme Court, there's excellent authority now that even in our current Supreme Court, that discrimination on the basis of sex includes discrimination on the basis of sexual orientation and sexual identity. I think this is a really important issue, and it actually creates some really interesting problems for constitutional interpretation, I suppose, if you're looking at what people thought it meant when they ratified an amendment, because I think our understandings have changed during the 40 years during the last 40 years. But I will say that for my kids, one of whom is non-binary and the other who is female, the very first question they asked me when I got involved with the ERA was, what does this mean for LGBTQ plus people? And I think the answer is, it means a lot. And that too should be an election issue in all the ways it matters.
Yeah. I'll just repeat. I'll try to repeat the question.
Both are important. Why both advocating for our public safety is important, and why moving Congress is also essential. When I have met with lawmakers on the other side for their staff, their first line of defense is a procedural argument. So they will take on the merits of the ERA or constitutional equality, but they're happy to stand behind that procedural argument. And so it seems to me it's really essential that the arguments you've made, Professor Sue and Professor Goodwin, are out there in the mainstream, and that the broad public is hearing you. I'm curious for you as academics, as scholars, how much of that you are open to doing, and maybe it's also a question in part for Professor Frankie and the ERA project. How much of a role might the ERA project play in putting this really out into the mainstream that absolutely there is an opportunity, this is legally valid, this is historically justified, and that there is a moment, there is a window, because I think on both sides of the aisle, there's not broad understanding of that, apart from maybe those that are deep in the movement and following your scholarship.
So I think it's a broad question about the sort of public-facing role of academic arguments and the willingness of academics to be enmeshed in activist politics.
The ERA project at Columbia is great at this. I don't feel myself very adept at the culture thing, you know. Though I hope the arguments will be useful to those who are. I guess I also haven't wanted to be a mansplainer, you know, on ERA issues, but to the extent the broader history is useful, I guess I will just punt on how to get it out there and say, I think there are 3 levels of arguments at which one could engage this kind of pushback you were describing. One is the legal arguments on the ERA, specifically a deadline, you know, was in the accompanying resolution, not the text, you know, so the arguments about why the ERA is in fact compliant with Article 5. But then 2, this point I was trying to emphasize about how there's nothing exceptional here. It's the norm that we would be having this conversation. Every amendment has had this kind of legal question surface. And then maybe 3, a point I think Julie was alluding to earlier, which is let's not forget that we have, many political scientists would say, the single most difficult to amend constitution in the world. We have the 2nd or 3rd lowest rate of amendment of any country in the world. So we're operating against the backdrop of a frozen, you know, undemocratic constitutional structure, which should make us all the more willing to be bold, you know, when amendments have plausibly satisfied the world's toughest threshold to get an amendment across the line. So that's the way I would think about it. But I'm sorry that I don't have better ideas on how to kind of socialize these arguments in the way you're describing.
Not sure I'd lean too hard on that 3rd one in our present legal culture, but please.
Really appreciate the question.
And want to turn all of you to the little brochure that's in your program that has a QR code in the back, and you can join our mailing list at the ERA project at Columbia and get all of these materials as they come hot off the press. If you go to our website, we've got FAQs, splainers, whenever a new court decision is coming down, either on state ERAs or federal ERA, whether there are things coming up in Congress, we explain them for regular folks through the work that we put out. I would also say that Professors Posen and Suk have also been, despite his humility, have written op-eds. He's got a wonderful one in the Washington Post. Professor Suk is frequently in popular media talking about the ERA and the amendment process. We need to do more of it, and that's part of why we're here today, is to conscript all of you in that project as well. But most importantly, join our mailing list.
Can I just say one quick word? I think it is also important to branch out. And I think that there has been a move of making the ERA not only an issue about women and gender nonconforming people, which it's most certainly and primarily is, but I think it ties into fundamental aspects of our democracy and its future. And I think this is so part of what's so upsetting about the status of the ERA is that the Constitution is essentially unamendable if we can't get the ERA into the US Constitution. I think we really haven't had a real amendment that was adopted by Congress and ratified by this many states ever since the 1970s, which was like over a generation ago. So I think that it's really important that not just people who are interested in the future of women, which is vital to our democracy, but also tying it into just the modernization and legitimacy of all of our institutions, because you could look at the history of the ERA in Congress and the history in state legislatures, why it took this long, as a story of many failures of democracy. And it's something that if we can't rectify it, our democracy is in real trouble. And I think that's something it's not just for me as an ERA expert to be talking about, but it's important that other academics who write in related fields and are interested in many aspects of our constitutional democracy need to be talking about. And the ERA has to be part of that conversation rather than an independent one.
I'll also say that Michele is a sort of dynamo when it comes to public engagement. So I wonder if she has any thoughts on sort of what the role of scholars are in this kind of open public debate.
You know, it brings to mind something that Jesse Jackson once said to me at a conference, at a convening with academics, and there was an academic who had a PowerPoint that just wouldn't go, and it was an audience of about 500 to 700 people. And a comment that he whispered to me is that, you know, you academics, you don't know how to talk to people. You just talk to each other. And I think that there is something to be said about the role of academics reaching out and finding ways that their work reaches the public. But I'd also say reaching beyond this is critically important and something that's been seen in other aspects. How do we socialize people to understand things? And that also means then beyond what might be in a news cycle, an op-ed or appearing on the news, also means gathering with people who also have expressive power as well. And we've seen some of this in spaces like Hollywood and elsewhere, where people are able to slip in really important messages that will be seen by broader viewership. There is a way in which academics and the desire to be taken seriously, which is very important, it's critically important, sometimes see themselves as just staying in a very narrow lane. But when we're talking about matters that affect people's lives in very broad and meaningful ways, it means sometimes thinking outside of the box and developing the kinds of relationships where we can spread a message deeper and wider within our communities. And I think that that's critically important. I'd like to pick up on something that was said by my co-panelist as well, and that is thinking about just what is at stake here. I think that there's already a crisis of our democracy. There's already a sense of the illegitimacy of our courts and also of our legislative bodies. There are the attacks now on the sitting president, deserved or undeserved. And I think that this has been a really tremendous administration, the Biden-Harris administration. But in so many areas of our polity, we find Americans who feel disheartened. So to your point, Professor Suk, I think that the ERA actually stands as a tremendous opportunity for us to think about getting this right in our democracy as actually a sign of hope. And I think that there's something that hasn't been framed. It hasn't been framed so much in that way. We've seen this as a measure of something that's important. It's important for women's equality. It's important for LGBTQ equality. It's important as we think about these things internationally. And all of those matters are completely legitimate. But I also think that there's something to be said about what's needed inspirationally within our government right now, what's needed inspirationally before our courts. And I think that getting this over the line is something that would be critically important to restoring perhaps a bit of faith in the United States and its institutions.
So I got an audience question that I think actually picks up right on that, which is, couldn't the Supreme Court interpret the ERA in a way that weakens it just as the Equal Protection Clause was weakened? I think it picks up on this issue that Michele was raising about the sort of broader significance that goes beyond mere legality. But I think there is it goes back to this discussion we were having earlier about constitutional culture. What good would an amendment do in the current context?
Well, certainly the Supreme Court could do that. And I think the Supreme Court could also, I could imagine the Supreme Court, notwithstanding the Bostock decision, the votes play out a little bit differently. And I could imagine some people in the Supreme Court concluding that because people in 1972 weren't thinking about trans rights. They were thinking about women's rights. That's all the ERA could mean. Now, I think you can guess what I would think of that conclusion, but yes, the Supreme Court could do a variety of things in interpreting the ERA. Also, we know that the 14th Amendment has been weakened in many ways because of the limits on what counts as discrimination and the high burden you have to satisfy in order to prove discrimination under the 14th Amendment. We could see those kinds of decisions as well. And this is why I think one thing we need to do as a movement, as a pro-equality movement, is to be doing all the work, right? And not be putting all of our faith in this particular mechanism. I think it's incredibly important for a whole bunch of reasons, but there's other equality work to do as well. A lot of it happens in state houses. A lot of it happens in local school boards. And it should be an equality movement in general. And hopefully the group of people that has come together around the ERA can see that as a place to put their efforts as well.
Maybe I'll just say briefly that just as it may take a change in our culture to get the ERA recognized as the 28th Amendment, or at least cultural work, I think if the ERA is recognized as 28th Amendment, it in turn will change our legal culture in ways that are potentially hard to predict. It's easy to say the Roberts Court's going to be no friend to the ERA, is going to construe it, in the most minimalist fashion. But if the ERA is widely recognized as 28th Amendment, it provides enforcement authority for Congress, which is going to start legislating. It will create a new set of expectations, I think, among Americans about what they now get from the Constitution. So I don't think it can be so confidently predicted that the court will gut it. Although, and I'll just amplify the point Linda made about Bostock being a useful resource. That was a statutory case, but it said that a guarantee of anti-discrimination guarantee around the word sex includes sexual orientation, gender identity. The Equal Protection Clause, which is now doing the constitutional work to protect sex equality, does not contain the word sex. The ERA does. And so it's a straight shot for a textualist like Justice Gorsuch to interpret the 28th Amendment more expansively than the 14th in that regard.
So I'll just add to the textualism. So one of the problems with the Supreme Court's interpretation of the 14th Amendment is that it's stuck in the 19th century. And I think that what you'll get with the ERA is a 20th century update. It is true that the Supreme Court can interpret the ERA in a manner that may not be the most friendly to feminism, but I do think that by its own preferred methodology, the original public meaning matters. And so it'd be original public meaning that you're getting from the early 1970s throughout the construction window up until 2020. And that was one of the reasons that I wrote the book when the state legislature started ratifying. I wanted to have on record what were women saying. They were updating the meaning of the Equal Rights Amendment, showing that in the 21st century, there was a continuity between the disadvantages discussed in the 1970s, some of which had been addressed by other laws, but some of which had not. And I think that that legislative history, in terms of the public meaning at the time of full ratification, which is in the 21st century, has to be something that matters to courts going into the future who are both originalist or textualist or living constitutionalists. And so I think in many ways, whatever the current Supreme Court will do with it, there are many more updated meanings that become impossible to ignore once you have text that was written in the 20th century and then ratified in the 21st century that needs to be interpreted.
Now, I would add to that something else, which is that we tend to think about our big federal elections, who's going to be elected as president, and we tend to think about the Supreme Court, but I would urge us to think about what these matters mean on a more local level. Not everything makes its way to the Supreme Court. It's sometimes the court can lean in and there's a case that goes quickly before the court because they decide to take it up. But there are ebbs and flows, and so much of what happens in American law happens at the lower court level. And there's something to be said about how people live and their real lived lives across the United States, and the power of an ERA in people's daily lives and matters that won't make its way to the Supreme Court, but infuses equality in how we rethink matters, whether it happens to be in questions that appear before school boards and local authorities to anything else. And it's that power which I think is really so important. While the Supreme Court is important for us to think about, especially given what's happened in recent years with this particular court, how it's now been reframed after the Trump administration, that notwithstanding, we can't lose sight of just what happens in people's lived lives day to day, and how a provision such as this might infuse something so incredibly meaningful and would in their lives before the court might take it up. And perhaps we don't know that the court would, but before this Supreme Court might do something to lessen its reach.
Yeah. So the question is, how important is it to deal with the opponents, including the Federalist Society, Leonard Leo, et cetera?
So when Kathleen Sullivan was testifying in the first Judiciary Committee hearing we had, which was before the House, one of the things she said was, any textualists in the House? And she was using the arguments of the textualists to support the position that Article 5 would recognize the ERA as the 28th Amendment. Can people who are opposed to the ERA be persuaded? I think for a certain group of people, the answer is probably no. But I think it's important to use the language and rely on those arguments. I think that has an important cultural impact, and it also kind of politically shows some of the difficulties with that proposition. If we begin to see textualism, what is called pure textualism, as in some sense being selective or infused with a political view, I think from a constitutional perspective, that could be useful depending on how you view the Constitution.
I'll just add that, if a theme of the panel has been there will be no magic moment at which the ERA becomes the 28th Amendment. It's a much more diffuse, decentralized, messy process of just enough actors agreeing that it is now the 20th Amendment. In that process, it could only help the more bipartisan it seems, and the more, red state officials and Republican federal officials say the ERA is 20th Amendment, the better. That suggests to me that if it's, and I don't know what's plausible here in the short or medium term, that it would be wonderful if the ERA coalition could get some Republican legislators to express the view that they think the ERA is now the 20th Amendment, or conservative scholars. Again, maybe that's a quixotic, hope, and just actually not worth the investment of time. But that I think strikes me, although no one can predict exactly how constitutional culture changes, as something that could be particularly helpful if this the more Republicans who engage here, the better.
Can I add a slight wrinkle to that, though? Because I think you're probably right, Dave. But on the other hand, to the extent that happens, it's likely to take the form of people saying, well, yeah, I support the ERA because it won't be all that big a change. It won't do anything radical, right? I support the ERA because it won't affect abortion, because it won't affect, LGBTQ plus rights, right? And that's why it's easy to support. And so, the more you broaden your tent, right, the more you may make it likely to pass, but the more you may water down sort of what the contemporaneous evidence of its meaning is.
I just say that evidence is already messy, and it seems to me the more vital first order task is to get the ERA recognized as part of the Constitution.
But I'd like to add something to that as well, Josh, which is, to your question, is it watered down? It gives the presumption that this would be something that all Republicans would not want to be on board with, or a significant portion of them. But I think about these ballot initiatives on abortion, for example, that have won in places where people did not expect them to win, right? So even the ones that would have been negative, let's say in the state of Kentucky, to instantiate an anti-abortion position within that state's constitution, that fails. And then the success of instantiating abortion rights and constitutions in places that would not have been anticipated. I think that there's a silence amongst what Republicans will actually sign on to. And I think these ballot initiatives are a part of it. Perhaps there just simply hasn't been enough of elevating who's really been behind supporting these, but that's not been a purely Democratic agenda. If we think about just who we are culturally in this country, before the Supreme Court was able to fully instantiate same-sex equality, there was already the momentum that was taking place across the country in states that were already doing that, including in places where people thought, well, that just won't happen because that's a red state legislature. And it was happening. And the same is true, I think, with the ballot initiatives with regard to abortion. There are people who have fuller lives that they're willing to acknowledge now, whether it happens to be LGBTQ, or on the other hand, whether it happens to be mothers and fathers, parents in Republican households who are looking at their daughters and thinking that it doesn't make sense that my daughter's life should be confined or cabined in such a way that would be produced by these anti-abortion bills. And they have been voting for these ballot initiatives. And so I think that we have to think about this in more nuanced ways rather than in ways that just suggest that there are really thick lines that separate Democrats and Republicans with regard to questions of modern day equality.
If I could just jump in, I think that's a really, really important point. And I just want to be clear, although I think there's probably a group of people on the far right who are not going to ever be persuaded, and they're going to rely on some of the procedural arguments as a way to probably mask their real opposition. The ERA has always been a bipartisan initiative. And there in every state that has ratified, those have all been bipartisan votes. The votes in Congress thus far have been bipartisan votes. I remember I was watching the live stream when my own state, the great state of Illinois, ratified in 2018. And one of the speeches that really turned the tide was a woman who stood up and said, I'm pro-life, and I've always been pro-life. And I'm going to vote for the ERA because my God tells me that my daughters are equal to my sons, and I'm still pro-life. And then she sat down. And I thought to myself, this thing is actually going to pass today. So there are a lot of people who bring a lot of different views to this topic. And I think it does make for a messy legislative record if you are going to care about finding, clear legislative history behind the ERA. But that's not what we do with the Constitution. This is a bipartisan effort, and it really needs to be. And I think it's just true that our culture is shifting in such a way that respect for equality is, when you set aside, a group of very far right politicians, respect for equality is a more common and widely accepted value of our culture.
I just want to say quickly, one thing I have noticed in the last few years in the House hearing and the Senate judiciary hearings is that I do think that the procedural arguments, which mask like a position that cannot be persuaded on equality and reproductive rights. I do think that one dynamic that we really do need to address and take seriously from the right is that they do seem to have the procedural upper hand. The idea that ratifying an amendment 40 years late is ridiculous, and so I see the people on the right, like Ted Cruz, shows up to these hearings really studied on the procedural issues, having read Coleman versus Miller, and Dillon versus Gloss and all the cases. And they have witnesses who are just kind of digging deep into the weeds of those procedural cases and then saying something that intuitively makes sense to people. When it's this late, it's not legitimate. And I think this is where it's really important that taking those arguments seriously and having real responses with regard to what the law and jurisprudence and history with regard to uncertainty about amendments is, about a constitutional tradition that most people on the right would affirm actually doesn't look as rigid as they might say it does. I think that piece of it, there's a lot of work amongst ERA proponents and possibility of persuading and finding middle ground. And I think that's the work that we need to do.
Okay, well, with apologies to people who still have questions, I think this time we are, in fact, done with the first panel. So once again, thank you to all of our panelists for fascinating things.